And welcome, everyone. It is Angelo Robles, and welcome to today's program, Family Office in HoldCo Legal Trends. It features a very special guest, Tom Handler. He's one of the most thoughtful, articulate, and opinionated attorneys in the community, probably in the US and more now internationally, among the best known pound for pound family business and family office attorneys. And it's a pleasure to have him on. Mr. Handler, how are you?
I'm well, thanks. Good morning, Angelo. We had a series of thunderstorms and tornadoes last night in Chicago. So the rivers that were 12 foot below the road level are now at road level. So it was an interesting night.
Well, they don't call it the Windy City for nothing, although I'm assuming that's more a perspective from politics, which is well earned in Chicago.
Well, I think that the origin was New York, and I think the people from New York were vying with the people of Chicago when they called us the second city. We didn't take it well, and their response was that we were the Windy City, not in terms of wind speed, but talking too much.
Well, that's a great history about the concept of the Windy City. And Tom, I know that there's lots of changes for you towards the end of our program. We'll give you a chance to articulate that somewhat to our audience. I did have a chance to queue up both my relationship with you for probably well into 17, 18 years now, and how I've enjoyed our conversations, and the subject that we're going to cover today. To give just the briefest of context, we're probably going to have about an hour, which again, by my standards, probably is a little bit on the shorter amount of time. We're going to cover a fair amount, or more than a fair amount, of family office and HoldCo legal trends. We're probably not going to take any one subject and do a 2-hour deep dive into it, because I think there's some broad trends that we need to cover that are going on that are going to be impactful to families. So on that note, Tom, and by the way, again, Family Office and HoldCo Legal Trends featuring Thomas J. Handler of Handler Law. Why don't we start, because I don't think you and I have really covered this before, and I think it's important. I'm a huge advocate of families owning, and maybe specifically buying and controlling private companies. There's various ways to do that, including more traditional, through a classic C-Corp, through an S-Corp, or more likely in today's world through an LLC. But I know that a lot of families of greater wealth create what's called HoldCos, holding companies. Break down a little bit why the legal mechanics around a HoldCo and why for certain families it may be advantageous.
Certainly. So this is important intelligence in the wealth industry in general. And it started with family limited partnerships, which are a type of HoldCo that have been around for a very long time. The evolution went from business corporate type HoldCos into conduit HoldCos that constitute partnerships for tax purposes. And those would include LLLPs in Canada, family limited partnerships, family limited liability companies, and series limited liability companies. And the series refers to the ability within the entity to have cells that are distinct for liability purposes, so that, for example, passive stocks and bonds could be in one series, an operating business in another, and a rental property in a third. And if something went wrong and a liability arose out of the operating business or the rental property, the plaintiffs are unable to climb over the wall and execute their judgment or go after the assets in the other series. So the series protect that bucket of assets. So in my example, the passive portfolio is never exposed to the operations of the real estate or the private business in this scenario. So those structures originated in other parts of the world, part of South America, Caribbean, elsewhere. And they've been around for some time, and they can be very beneficial. In the States, I'm going to believe roughly 16 states and 2 or 3 territories have passed the series LLC statutes, and a few more are contemplating them, so they haven't been adopted everywhere. but they're very useful when they can be. So the idea is that these holdcos allow you to organize in a bucket all of the assets. And if you're concerned about liability and you don't use a series type structure, or even if you do, maybe you have the operating company in an LLC or a corporation, so the individuals are not personally liable, or you pop them into an LLC to protect them in that bucket, and that LLC in turn goes into the family holdco, and that we call the Mike Ditka approach. When Ditka was quarterbacking the '86 Super Bowl Bears, he was a spokesman for a big time clothing company in Chicago. He'd wear braces and a belt. And the reporter said, well, Mr. Ditka, normally he'll wear either braces or a belt, but not both. And he said, well, when you're trying to keep your pants on, you can't be too damn sure. So the point is the same, that we have a fallback position to our basic position. So 2 levels of asset protection using the series. The other benefit is in a family limited partnership, the general partner is personally liable, which forces you to organize in a non-liability entity, such as an LLC or a corporation. In limited liability companies, by contrast, the manager or the managing member are not personally liable. So you have an extra level of benefit. You still may want to be a benefit for various purposes, but that operator is not personally liable, which is a huge advantage in itself. Also, starting with an LLC, you can be taxed as a partnership. You can elect to be taxed as an S-Corp. You can ultimately elect to be taxed as a C-Corp, and you don't have to change the enterprise. So it's a matter of filing elections. Whereas if you start as a C-Corp, you can't go backwards and become a conduit. You have to dissolve that enterprise, reorganize, and do other things to make that happen. So it's a handy vehicle. So aside from the organization, which is significant, the discipline of running a holding company means that people are watching the store better. Hopefully, the in-house counsel or the local counsel or the family themselves. And so it's less likely to incur a problem that will taint, commingle, or transmute the assets and turn them into marital property. So the assets in these buckets that were non-marital property stay non-marital property. And if you don't do something inappropriate, they remain that way. So if the prenup or the postnup don't work, the premarital planning benefit of those holding companies is very significant. And many families will put them in place just to make sure that their businesses or their assets go to their lineal descendants and their grandchildren. So that's a good reason in itself. So that protection, that marital planning protection, is quite significant and often overlooked. In addition, assets in these vehicles, these holdcos, the IRS helped write the laws that relate to valuation and putting premiums on a control interest. Well, the flip side of that is discounts when you have lack of control, and discounts on a large block, and discounts for lack of marketability, and various other discounts. And so those discounts are pretty significant. So the asset held outright, you own $10,000 of some public company. Well, it's $10,000. That same $10,000 in a family holdco with businesses and real estate and hedge funds and private equity and other assets, that $10,000 may only be $6,000 or $6,500. So the discounts are quite substantial. They've ranged, in my experience, from 15% on the low side to 74% on the high side that the IRS audited and granted. Don't expect that. I've never seen anything quite like that. I actually advised the client not to take that discount. I thought it was too high. Most of the discounts come in the 30 to 40% range off of the valuation firms. And in our client base, based upon the 3 most recent audits of very large $20 to $120 million transactions, the net result was that those clients ended up with discounts over 35% after IRS examination, which is interesting, without going to appeal to the appellate conferee or on to tax court or any other venue. The IRS audit examination manual specifically says that they are to challenge all discounts over 25%, which might lead you to believe that 25% perhaps looked a little bit like a safe harbor, though there's no reason they can't challenge it if it's below 25%, but it gives you at least a baseline. And in our case, they didn't challenge it, and I think they're just being prudent. They're allocating their resources to cases where they have a bigger opportunity of raising revenue and being cost effective. And they're not going to go at the well done cases. So where it's tightly buttoned up, the documents are well done, the evaluations are well executed, the declarations of gifts are appropriate, the trustees acknowledge those gifts, the custodians registered the transfers, gift tax return was filed, valuation was attached. They don't want to fight those cases because they're not going to win many of them. It's not a good place to spend their money. So I think they're being prudent, and they're going after the cases where they think they have an opportunity. So the discounting is quite significant. So if I have $20 million of assets and I own them outright, it's $20 million of my estate. Those same $20 million in a HoldCo, even if I own 100% of it, suddenly looks like 12 million, 13 million, who knows what the number is based on the valuation. And that's a big deal because that discount I can also use during my life to sell those assets at that discount or to gift those assets at a discount. So I can use the annual gifts. So maybe I can give 21, 22, 23 grand per child or grandchild and not be limited to the annual exclusion amount. Or the federal exclusion currently at 3.61 million per individual, 27.22 million for a married couple. You can leverage that up. So maybe that 13.6 million turns into 18, 19, 20 million, again, depending on the discount. So it is a significant estate tax and gift tax saving discount as well that is in part helped by these family holdcos. And not that there might not be a discount for a minority interest in a company anyway, there would be, but the discount will be magnified with the use of these structures to specifically limit the assets, don't provide control, don't provide great marketability. And that's purposeful, one, because typically the oldest generation is controlling those assets because they view them as theirs. And then secondly, we don't want to give the IRS arguments to reduce the discounts to levels that we find unacceptable. And then ultimately, if these holdcos are set up in one of 3 U.S. states or about a dozen international jurisdictions, they bring with them very significant asset protection in that the creditors and plaintiffs are limited in terms of the remedies. So in a state like Illinois, you can use laches, estoppel, the assets can be frozen, you have a constructive trust, you could have a sheriff's sale, you could take over the company, you have rights to books and records. There's pretty much nothing that can't be done under law or chancery when chasing a defendant in a place like Illinois, and that's most states. In these few states, however, and these international jurisdictions, the plaintiffs are very limited in what they're able to do. And what that does, in effect, is provide significant asset protection for the families and keeps outside third parties from interjecting themselves into the family business. They have no access to books and records. They can't come to your meetings. They have no right to take control of the company or to take the equity in those enterprises. So it's a very significant asset protection play for third-party creditors, as well as divorcing spouses, child custody matters, those sort of things. So the privacy and the ability to avoid a lot of legal fees and discovery is really quite significant. So the asset protection element is very sound. So in effect, it's a good business structure because it's organized. It facilitates marital planning because it allows the assets to retain their character. And with people watching, they're far less likely to be tainted, transmuted, or commingled, which are the theories the various states and territories use to turn non-marital property into marital property. The discount provides significant gift and estate tax savings, even if you don't give anything away or sell it. And then ultimately, the liability protection, the asset protection by virtue of these lack of remedies that people have. So these are very, very powerful vehicles that should be almost standard. People have been doing these for a long time. We inherited a client that had 14 or 15 of these in place before we got there. That was probably overkill, probably didn't need quite that many, but the point is that these are very effective vehicles. And in the series situation, you're paying for the operating agreement once. So each series constitutes a separate entity, so it's got a tax return, but you've got one operating agreement, one set of minutes and resolutions. So there is some legal efficiency in the process as well that helps provide that asset protection. So I'll stop there for a moment, Angelo. Does that make sense?
I know that makes a lot of sense. Of course, I know the audience is wondering, and one of the states better be Wyoming. What are the three states that you think offer the most from a privacy and asset protection perspective?
So it's quite clear, actually. It's not much of a debate. For people that do this, the top states in no particular order are Delaware and Alaska, and Wyoming recently passed the statute in 2023. So it's the newcomer to this regime. So those are the three U.S. states. And of course, there's these international jurisdictions have been around for a lot longer. And the U.S. states, in effect, copied the laws from some of these international jurisdictions.
I don't mean to get too far off track, but you mentioned Delaware. Delaware has been a stalwart in the community for corporations and for some of the reasons that you're noting for hundreds of years. Recently, there was the issue with Elon Musk and Tesla that shined what some would argue a little bit of a negative light on Delaware as he's considering and working on transferring it from legal purposes to Texas. Is there some concern that Delaware has been weaponized politically and that Alaska, Wyoming, and other states may start to take some of their shine away?
I think you're absolutely correct. And the Elon Musk case, in my opinion, was an egregious mistake. Violated contract law. I don't get it. I don't know how the judge justified it. I don't know her, nor do I care to. But they've also done a couple of other things, smaller things, not quite as monumental, that also would militate against using Delaware. So if they don't, I mean, they've had the longest commitment, and their advantage has been the length and consistency of their commitment to efficiency and facilitating business operations. These recent developments are very adverse, and everyone's watching to see what happens. And I have no doubt that other states are going to pick up significant entities because Delaware will certainly lose some. So if they don't fix this or stop this trend, it's going to cost them dearly. And I think they'll determine that these things they're doing are ultimately a mistake and misguided if their goal was to continue to be a leading state for fostering successful businesses. It's problematic, and I think you're exactly right. People will go elsewhere more than they would usually. The other benefit of Delaware is that it has a fairly sophisticated bar and judiciary. They've been around longer, and so they're ahead of Wyoming and Alaska. For LLC purposes, they're ahead of other states for corporate and business law purposes. But of course, over time that changes. As states get populated, the professional services tend to lag behind the population, but sooner or later they catch up. It may take 25 years, but eventually the caliber of professional services will rise to meet the population. And if not, people in those areas will go outside and they'll hire people in New York, Chicago, Silicon Valley, which is the norm in any event.
Of course. And a couple of comments coming in from our live audience. One, Robert, thank you. And one from Dan, and I was going to ask this question as well. We may get to them a little bit in private trust companies, which we'll just give a little bit of shine to relatively shortly. But he asked, how about South Dakota?
South Dakota's got very good laws for business. For purposes of the LLC statute, they haven't enacted the same laws as Delaware, Alaska, and Wyoming. They likely will eventually, if I had to guess. But these things typically take time. So the states that are trying to be in the business or are in the business of being favorable jurisdictions to operate entities, trusts, private trust companies, businesses, family holdcos in general, they tend to watch what other people do. And then for the things they like, they tend to add them over time. So there's a little bit of a competition among states like Florida, Texas, South Dakota, Tennessee, vying for that business. And over time, they start coming together. And the winner tends to be, who's the most innovative, who leads it, who's the thought leader in that area to create those efficiencies, and then who keeps up. So over time, we'll be able to figure that out. So South Dakota is a great jurisdiction. We use it for many purposes. And we do have family holdcos there, but it's not as efficient for this particular asset protection purpose in limiting the remedies available to creditors. Many states have it by case law. And the dilemma is that that case law could change by the end of this discussion. So we don't rely on case law because it's not cast in stone. I want to see a statute that says this is the exclusive remedy and the judiciary cannot circumnavigate it. When it says that, then that tells me that's where I want to be. So we don't trust the case law because at the end of the day, this is about keeping people's wherewithal. This might be their start over fund. They don't want to lose these assets. So these are near and dear assets. In many cases, the older generation spent their entire life working for, taking risk and amassing these assets. The last thing they want to see is have them washed away in one fell swoop by a spurious lawsuit or an incorrect lawsuit or just something bad that happens.
And Tom, an anonymous is asking, he's still perhaps a little confused. Is the verbiage HoldCo really just an outdated or verbiage that we use? In reality, what is usually the underlying structure? Is it a C-Corp? Is it a family limited partnership? Is it an LLC? In theory, could it be any or all of the three? And what advantages?
Sure. So in a business context where it's not also including passive investments in real estate and vacation homes and other things that are typically in family holdcos run by family offices. In the business context, there are often tax and benefit reasons to use holdcos, and we use them all the time. In some situations, we have a series of holdcos that are C corporations, and there's 50 of them around the world, and there's a second tranche of S corporations, and there's 50 of them around the world, and there's the newer tranche are the LLCs, and there's 30 of them, and all the new ones are LLCs because they're flexibility. What drives that are often tax and estate considerations. The S corporation is the most problematic vehicle for estate planning purposes. It's more difficult to do what we want to do, and you're limited in terms of the shareholders and certain things without involuntarily using your election, but it was the best game in town for a long time. Citizens wanted a vehicle that had conduit income tax treatment, but where they weren't personally liable. And that's the role the S-Corp fulfilled. When LLCs came out, it's a better vehicle because you don't have the built-in gains tax of the LLC. You can have foreign investors and shareholders. You can have bigger organizations. So you're not limited by the S corporation rules. There are good reasons to have S corporations, largely relating to payroll and benefits and employment taxes, but they're not so good for estate planning purposes and or growing the business. LLCs can be infinitely upgraded, and so they're often used. And the business C-Corp holding company is popular because if you want to access the public markets, you're going to be a C-Corp. And even if you started something else, ultimately, you're going to have a parent corporate sub that reverse merges in, or you're going to form a C-Corp that ultimately goes public. So you're going to end up there anyway. But one of the key benefits is Section 1202, qualified small business stock. And this came out 15, 16 years ago. And when they initially came out with it, it wasn't well drafted. They didn't run the numbers very carefully. And the result was for the accountants and lawyers that took the time to learn it and analyze it, it turned out your client had to comply with all these rules, end up with C corporation's tax status, which means the corporation pays tax in its own right, then the individuals pay tax when they get the dividends out of it. So there's two levels of taxation automatically. The benefit under the original 1202 was like 1%. So the income tax savings was not compelling and nobody did it. So for the most part, they were totally unused and ignored. And most people haven't even looked at them to see if they're beneficial today, but of course they are. So during the Obama term, someone figured out that they botched the statute. And I like the qualified small business rules because it's an incubator, it creates jobs, and it's a win-win. There's a big tax benefit up front to get the business started and create jobs and do all the things it takes to start a larger business. And when it works, that business is a C Corp down the road where the taxpayers get paid back and then some. So it's a win-win across the board. It was very well done the second time around. So I'm a big fan of 1202. But in order to have 1202, you have to be a C corporation. So many companies will start as an LLC holding company structure, but try to comply with the rules because their intent is to, down the road, make that C Corp election to become a 1202 company. So you don't get the 1202 holding period until you make that election to become a C-Corp. It's a 5-year holding period. So if you're an LLC for 3 years because you want to pass through the losses in the early years, you're going to spend a bunch of money and you have no revenue. You want the investors to get the benefit of those losses. When it starts to look like it's turning around, you make the C election. After a 5-year holding period, you have a huge capital gain exclusion, which is extremely beneficial, $50 million avoidance of capital gain. And you could do series 1202s. You have multiple structures. It might even be larger than that. So it's very, very consequential. And even if you don't hold it 5 years before you ultimately sell it or take it public, whatever you're going to do, if you take those proceeds and roll them into another 1202 company, you can meet the holding period in the second company, or for that matter, diversify into 5 1202s. And as long as you meet the 5-year holding period, then those capital gains on those future companies would also avoid the capital gains tax. And given the Biden proposal to raise that capital gains tax to 43.6%, you're well advised to avoid capital gains taxes currently, even at their current rate. But if that rate goes up, which was in his original Green Book and brought up 2 months ago, it's a very, very significant, I would argue, confiscatory tax on top of the income tax. So you paid payroll tax to earn the money and income tax, then you invested it, and now when you sell it, now you're going to pay a capital gains tax. Then when you die, whether you sell it or not, you're going to pay a capital gains tax again in the estate. So that collective pile is misguided, in my opinion, and an extremely confiscatory tax. I hope it goes nowhere. But given that risk, this 1202 opportunity to avoid capital gains is very significant. So the business decision is going to be made on, do you need to access the capital markets? Does the private equity or venture firm force you into that structure for some other reason? Or are you just warehousing tons of money and you want to be able to retain those earnings in the C corporation, pay a low lever tax because you're going to keep reinvesting in the company? That's another reason to do it. So the decision is complicated, and you literally want to run through a decision matrix of what's the most common scenario, what's expected, what's the business plan say, build some fat in that. Maybe it takes a little longer. Then you make your entity choice of entity decisions based on what's going to work most of the time for most of the investors and achieve the best results. And it's not a simple analysis to get those right.
Yes, I think as the audience is understanding what we're loosely defining as holdcos and the asset protection, the family benefits, the estate benefits, there's a variety of reasons. It is complex, and honestly, it is worthy for probably a 2-hour discussion for my members to do a deeper dive, but we'll save that for maybe some time into the fall. But I do have to ask, people do hear about, well, Warren Buffett purchased the late 50s, early 60s, a textile company called Berkshire Hathaway. That became his anchor cash flow holding company that he then built upon. Now, he had certain advantages, especially back in the 70s, of insurance company and bank holdings that would be a little bit more complex in today's world. But you could take a holding company and add to it, and it could become giant. If you could talk a little bit on how maybe Berkshire Hathaway, as an example that families could relate to, how a holding company could continue and grow and be, in his example, primarily through the insurance, be tax advantageous.
Sure. So one of the advantages of insurance companies, of which Warren Buffett is highly involved, he owns reinsurance and insurance and banking and finance. And one of the keys is that the reserves in those companies can sit there for a long period of time, and you don't get hit with excess accumulated earnings. You don't get hit with a retained earnings tax. You don't have a problem by retaining the capital, and it allows you to reinvest. And when the corporate rate is lower than the individual tax rate, you're arbitraging that rate and putting that much more money into your new investments, which of course Warren did very handily. So the expenses of the insurance paid by all of his companies to his insurance companies and ultimately reinsured to his reinsurance companies are deductions. So it's coming off of their taxable line. The insurance companies then have deductions as they're paying things out over time. They can carry these fairly significant reserves into the future. They can invest in things, and they often do, which is why you get portfolio earnings, on life insurance, for example. If you have cash value, whole life, or variable universal life type insurance, there's a cash surrender value in there, and that's really an investment portfolio growing income tax free inside of the insurance policy. And similarly, the insurance company's not paying tax on that as well. And the same thing would apply to private placement policies, which look just like that, but tend to have a more sophisticated investment element to it. So those are very good long-term wealth building vehicles. And I will analogize the private placement and indexed VUL policies to having your own insurance company. It's as close as you can get to having your own captive life insurance company. And I only know of 2 families in the US that have them, one in Minnesota, one in Chicago. They did these in the 60s when the capital requirements weren't as high. And they have billions and billions of dollars in those companies, growing tax-free. They're keeping their own commissions. They're buying their insurance wholesale, and it's growing inside the policies, income tax-free. And then if they do it right, it may or may not be includable in the estate, depending on the decisions the individual family members made. So very, very strategic and brilliant strategy. But to do it as an individual, we did a study maybe 10 years ago for a $3 billion family. And it was about, yay thick. We told them not to do the study because I knew the answer without doing the study. And they said, do it anyway. So we did. And the conclusion was, you don't have enough capital. This will tie up so much of your capital, you'll have nothing less left to run your operating businesses. So the barriers to entry are very significant. So these private placement policies, 6 New York families got together and formed their own little captive to do it because one individual family was taking up too much capital. Then some foreign companies owned in part by Americans started offering these at minimum $10 million premiums, huge policies. And then over time, it became retail to where now you can buy smaller policies. It's available to more people. It's still, it's only accessible to millionaires, but the costs have come down and they still are very cost effective. It's about as close as you can get to having your own life insurance company. So the Warren Buffett strategy over the long term was relatively brilliant. And even if they buy a company that's an LLC or an S-Corp, they can operate it that way outside of the HoldCo for a period of time. But when it makes sense, they're building it and growing it, was typically his strategy to build it and grow it. They terminate that election, make it a C-Corp, fold it into the HoldCo at that point, and then off it goes. One of our clients in the Midwest has approximately 130 entities, and it's a global insurance conglomerate. And they've got these siphons. They've got the S-Corp regime and an LLC regime, and they're kind of running separately, but everything goes into these holdcos to get the benefits that I just discussed. So it can be a very compelling strategy over the long haul. The key is to know how to maximize the income tax benefits up front, try to keep the deductions if you're in a net operating loss position, and then to know when to flip to maximize the ability to retain capital in the company and reinvest it in the business, and or to get that 1202 qualified small business stock benefit to avoid very significant capital gains. So again, a pretty complex analysis, but you can get there.
No, very good, Tom. And the audience listening in, I did open it up beyond my members on YouTube in December of the past year, 2023. I did a pretty comprehensive interview with Michael Liebeskind. I have covered private placement life insurance multiple times. I've been a huge advocate, and that was a pretty comprehensive hour-and-a-half discussion from this past December on the subject. You did mention net operating losses, NOLs. This does anyone who's active in building and or buying private companies and keeping them inside, quote unquote, a holdco. There are going to be certain times when not every company is going to be profitable. You might be able to get some tax arbitrage off something that is currently a net operating loss. Talk a little bit about weaving multiple companies into a so-called holdco and the utilization of net operating losses, which could be temporary for a year or two to offset profits until it's folded greater into the profits. And I'm probably making it more complicated than it needs to be, but the reality is it is a little bit complicated.
Well, that's a good question. And you're right. Sophisticated companies are consistently running projections and forecasts on where they're headed. So they tend to watch this pretty closely. The companies that are profitable have estimated tax obligations. Nobody wants interest and penalties at high rates if you can avoid it. So you need to make sure you're paid in, or you need to make sure that it's sheltered. So in the process of forecasting with some confidence interval and some knowing there's going to be some error, companies will try to equalize these and use the losses to offset the operating income when it can. And it's a very effective strategy. Often you're not going to be 100% perfect, but if you're batting 80 or 90%, that's very efficient and can really help the companies grow and free up capital you would otherwise pay to taxes to put back in the company, create jobs, build the businesses, and do all kinds of positive things. So it's a similar complicated analysis, but it's one well worth doing, and that's precisely what companies do. And a wrench got thrown into this mess by the TCJA, and people have learned this the hard way. So when you have a net operating loss from your various business activities, including operating real estate that you participate in, or you have 500 hours in an activity, if at the end of the day you've got this net operating loss, the dilemma is the TCJA defers it for 1 year. So that runs through the end of 2025. So a lot of our clients bought companies anticipating these losses. The net losses, in effect, won't offset income from other sources because they're capped and deferred 1 year under this rule. And most people didn't know that. So a lot of the planning was done unaware that this rule is a trap and can block the utilization for 1 year. So it's been deferring it 1 year forward since the TCJA, and it's caused a lot of problems for our clients that would have otherwise had losses they could use to offset very significant income. So there are all kinds of limitations on losses. You've got at-risk rules, basis limitations, active passive limitations. So this is not an exercise for the faint of heart. You need to go into this and do some pretty sophisticated analysis to get it right. But when you do, it should free up capital for the company, help you operate better, and hopefully you get to build a business like Warren Buffett.
Of course. And giving you an example leading into my next question, I create a holding company. I identify what I think is a opportunity in a given vertical, whatever. Let's say it's RV parks. I know enough about it to be dangerous. I want to do it, but I'm not necessarily going to be 24/7 and an expert in it. I look to bring in an operator. We're going to work together on rolling up. Now, in a perfect world, a great salary and bonus and carry is going to cut it most of the time. But you will come across some people, maybe not in the vertical or industry that I noted, where to attract top tier talent, they may need to have a piece of the equity. How could I work within a holding company structure and which one of the entities, LLC, S-Corp, or C-Corp, where I could provide with a level of golden handcuffs, equity participation in a given roll-up strategy or one specific one-off company that I'm doing?
Sure. So the overall answer is that you can affect those strategies in any of those entities, but they're easier with the C-Corps, right? That's the reality. And we've done this kind of executive comp benefits planning for public companies and its executives, and it's time well spent because it's efficient money. It either will be, there might be a partial tax benefit or much of it might not be taxable. So it's a smart strategy to go through. And it's typically going to be subject to a vesting schedule, right? That you're not just going to dump the equity up front. There's kind of an earnout or a period where people have to be locked in for a period of time. So that vesting, 3 years, 5 years, 7 years, whatever it is a golden handcuffs. The people aren't likely to exit until they realize the benefit of that work. So that's an effective strategy as well. And on the front end, if they want their interest to be capital gain, there are often strategies where they can exercise and the options or warrants, take the stock, subject to forfeiture potentially, but they have it, and they can make an election that in effect, when they get paid, it's capital gain and not all ordinary income. So to the extent that ordinary income is closer to 40%, which it will be when the TCJA sunsets on December 31, 2025, income tax rates go up, estate tax rates go up, and the estate tax exclusion drops precipitously, likely roughly half of what it is today or less. So in view of that, timing matters on when you do this, but there are pretty solid strategies. And a profits interest is nice. The equity interest might even be better. And so a lot of the operators would prefer to ultimately have equity or have equity plus a profits interest. But when you've got that equity stake, you're in the same base as everybody else. And so that equity could be limited to one of the subsidiaries in the HoldCo,
Right.
or it could be at the HoldCo level, depending on what they're doing. If it's board service for the whole enterprise, they might have options or stock grants on the HoldCo because they're helping the whole enterprise. If they're working or on the board of the subsidiaries, their equity is typically to be limited to that enterprise or related enterprises in a group, for example. So you can pretty much customize those as you deem appropriate in a manner that you think helps you attract the best talent and provides compensation that helps ensure that they'll be around and loyal and not leave until the vesting occurs.
Of course. And you're talking to someone, my audience now, that I'm going through that in what I'm looking to do in Wyoming, in creating a holding company and verticals that I'm looking at that I could, some of them, handle myself as one-offs. But in looking to do roll-ups in certain industries, I want to bring in a top-level person. I have absolutely found that if they're really top level, you're probably going to have to engage them in more than just bonus and carry as their sweetener. And I think there's going to be greater alignment with equity. But knowing how to do that and structure it right is a little bit of art and science in the industry. Perhaps well, I think that probably wraps up on the holdcos. Again, we could do a whole 2 or 3 hours, which I would love to do, dedicated to my members on that. And those of you that would like a connection to Tom, of course, you could always, especially members of SFO Continuity, reach out to me, and I'm happy to do that. When we're talking about holdcos and companies and intertwining trustees and decisions and processes, I can't help but not think of private trust companies. Now, again, Tom, we're going to have maybe 5 minutes to talk about it. To give my audience some context, this summer into early fall, we'll be having on Al King III of South Dakota Trust Company, Laurent Drew, who's based in Wyoming, as more focused on unregulated private trust companies. So we will have deep dive intellectual capital on private trust companies, but talk a little bit, maybe broadly speaking, on the value of a private trust company from a governance and trustee perspective.
So I'll start by saying, so far, everyone you've mentioned, we know and have worked with. So you're picking top operators, and the audience will benefit from hearing from those folks, or have already benefited from what are some of the top people in the business. I'm a fan of private trust companies. They are a very effective strategy used by many family offices. And I think the mistake is often made thinking that the private trust company is an alternative to the family office, and it really isn't.
Yes,
They work hand in hand. And so the white paper that I worked on with you, Angelo, has a schematic showing a complex family office, and it shows they could have an RIA, a broker dealer, a captive property and casualty company, a subsidiary in another jurisdiction, and a private trust company. So the private trust company is really effective if the family wants to control at a high level its own trust and its own investments. And it's very effective at doing that. And there are some jurisdictions that are exceptional at this, and good administrators that facilitate this process and make it much easier. The key is that the private trust company should work in conjunction with the family office, because the family office can legitimately deduct expenses that are not deductible elsewhere. So trusts have certain expenses they can deduct. Private trust company has certain expenses, and the family office has certain expenses. And without those entities, you're not going to get the other expenses. So that the structure matters. And the private trust company is just a great way to have more control over the trusts. But make no mistake, it's a business, and you have, just like the family office, even if you have a virtual family office, you have to operate like a business, and you have to pay attention to it. And it's not just like something you set up and ignore and go look at 5 years later. It's much like the family office, that you've got to run it and operate it and do what's required under the regulations to afford it. But I love it for the level of control and privacy that you can achieve using them. And that's a very big driver. So I would say that perhaps 8 to 10% of our client base has one or more family office structures, including a private trust company.
Excellent. Then again, we have plenty of content upcoming on it. There have been some older 2 or 3-year-old interviews that will be up on @FamilyOffice that will cover that as well. And yes, I'm an extreme advocate of a private trust company, and you should understand the nuances of regulated, unregulated, and advantages and disadvantages. But again, that's upcoming. But if you're going to have a family office, if you're going to have a HoldCo, then I kind of don't understand if you don't also have a private trust company. To me, it makes no sense, but at the end of the day, your call. We probably have about 15 more minutes left. I have a couple of questions for Tom. And then again, he has some pretty big news from his perspective for those of you that may not be familiar. But Tom, and maybe this is a selfish question for me again, in my debate I did with Jamie McLaughlin last week on, from my perspective, the value of a single family office and so-called smaller, meaning often sub-billion-dollar single family offices, there also is the issue of, even using, again, me as an example, relatively small family units. It may be me, a spouse, and a child, me, a spouse, and 2 children. It basically 2 to 5 to 7, not the big sprawling families like we saw in Lender versus the IRS that made that case perfect for the lender family, but may not always apply to other families that don't have similar structures or the voluminous of multiple branches and generational family members. So for smaller family units, whether it's 100 million or whether it's 100 billion, the lender versus IRS model, as it was outlined now going back 8 or 9 years ago, may not be perfect for someone like me. Now, again, we could do 2 hours on this one as well. In relatively a short amount of time, what structure should I be using? Is it a C-Corp, still treated as a for-profit business, so I get the tax advantages of a family office? But what are some of the nuances, again, the art and science that goes into the design?
Sure. So just a quick comment on lender. And I talked to those folks when the audit was going on, and I didn't think the IRS would take it up because we've had roughly 35 examinations of clients and we've never had any disallowance whatsoever. So I was surprised that they were going at it. The case didn't address a number of key issues, unfortunately. And I think the court made a pretty egregious decision in one aspect that I don't know if they argued it improperly or what, but I think that would get overturned. So I don't think the lender structure is a particularly good structure. It's certainly not elegant. It worked, but I would not have done it that way. Let's put it that way. Yet it provides some good guidance on what you can and can't do. So I'm not suggesting not to follow lender. I'm just saying it's not the end of the analysis by any stretch of the imagination. I'm going to suggest that over 80%, maybe 85% of family offices are set up as C-Corps at this point, and the balance tend to be LLCs or S-Corps. So the decision has been almost universal to use some non-liability entity. Nobody wants to be able to be personally sued for whatever the family office does. So only non-liability entities tend to be the winners. And in foreign countries, they're the equivalents of a C-Corp or a non-liability LLC are being used. The benefit of the C-Corp is that you have some presumptions running your way as well. And those are subtle, but meaningful to the extent that you get challenged. For smaller families or even large families, sometimes they will start the entity off as an LLC taxed as a conduit, because chances are during the setup period, the first year and a half, 2 years, they're going to spend a lot of money. And they might spend more money than they earn because, again, they're dumping the assets into this bucket. They may not mature. The private equity is not going to pay out for 5 years or 7 years or whatever. So they got losses in the early years. They want to use those losses. So they may start off with a conduit entity, LLC or an S-Corp, and then the minute the switch flips and they're having more income, now they'll often turn into a C corporation, and whatever capital they want to retain in that entity is being retained at a far lower rate and not intending to be paid out in the future. So C Corp is almost always where we're headed, but that doesn't mean it can't start out as something else. and then evolve into a more sophisticated structure down the road. So the virtual family office in particular, which I've spoken about a lot, can start as an S-Corp, LLC, or C-Corp, but it's designed based on the understanding that costs are escalating faster than revenues in family offices, as a general rule based on the research. And so the squeeze or hunt for top talents become more challenging, and that top talents become more expensive, and there's not enough people out there in the first place. So the result is that outsourcing has been on the increase for 25 years. And the most common things outsourced are legal, accounting, and investment advice. And so people are going out to get the expertise because they can't afford 8 analysts and 2 investment managers and a senior in-house counsel and a senior CIO and so on and so forth. So that outsourcing trend is across the board, including billionaire and multi-billionaire families. We work with a billionaire family out of Iowa, and they're a virtual family office. They have 2 employees, 1 lawyer and 1 CPA, and they really just outsource everything and manage the affairs. So the VFO can extend into larger structures, but typically they tend to be smaller assets under management, and then over time they may flip down the road. So there's no real right or wrong answer to say how you should start, but most advisors have opted on the side of the C corporation, and if not initially, within the first 3 to 5 years.
And in C corporation, there's obviously shareholders. Is the shareholder specific individuals? Is it a trust company? How is that structured?
The shareholders are often trusts, sometimes in a private trust company, or trusts where they are their living trust, where they're their own trustee. So the older generations may control those, and often they pass on the reins of the family office with specific bequests, because if they have 7 children and they want 2 to run the office, they'll give the stock of the family office to just those children, in part because it doesn't have much value. There's typically not a lot there. There's some technology and there's employees and liabilities, but it's not a big source of capital. No one's keeping tens of millions of dollars in the family office entity. If there's tens of millions of dollars, it's parked down there in the holding companies run by the family office. And to get the benefit of the expenses in the family office, the TCJA eliminated about 50 expenses that fall into 4 buckets: tax item, lawyers, accountants, and investment advisors. So individuals today cannot deduct investment advisory fees, investment research, investment analysis, investment reports, investment trips, investment seminars, investment litigation, tax planning, tax prep, tax appeals, tax audits, tax letter rulings, private letter. None of that stuff's deductible. The only place you're going to get that deduction is in the family office enterprise. So that alone typically will pay for the family office setup with money left over. The bigger billionaire families, they're typically recovering 3 times the total legal fee in the first year in first-year income tax savings alone, even though income tax was not a driver of the project. The project was driven by S protection or business planning or estate planning, and the income tax was just an afterthought, but it ends up being the icing on the cake. So these structures are very tax efficient and can eliminate a lot of income tax leakage, which frankly, the vast majority of family offices out there, if they weren't set up in the last 5 years, are almost assuredly loaded up with income tax leakage and often estate tax leakage as well. So there's almost unlimited work here. At the high end of the market, there's unlimited tax and estate work. It isn't going to go away anytime soon. And given the sunset of the TCJA, if you haven't used your full exclusion, I highly suggest that you use it. If you're a large family, I would leverage it up as much as you can using the discounts in a holding company and making sales and gifts. But if you don't use that exclusion by December 31, 2025, it's gone. And I wouldn't wait till the 4th quarter, because you aren't going to find a lawyer or a CPA or a valuation firm available, because they're all going to be completely jammed up with people that hired them during the summer. So you want to get at this sooner rather than later to go ahead and affect those gifts. And the IRS has come out informally and said they have no intention of recapturing those exclusions. They're not going to go back and try to get them. So you should be relatively safe. If you use them, it's done. And if you don't use them and it drops, the exclusion drops to, let's say, 6.5 million, 7 on January 1, 2026, it's over. You have no access to those previous exclusions. So you want to use them sooner rather than later. So as a result of the income tax rate goes back to 39.6, the estate rate goes up to 45, and the exclusion is going to drop in half or less. We don't know. It depends on interest rates, but it's going to drop precipitously. That's driving tremendous tax and estate planning that will just come to a fever pitch in the fourth quarter of next year.
Of course. And perhaps the last topic, again, a little shorter than most of the programs that I do. One, Tom has a busy schedule, and two, I have to get up and figure out a way to get into New York City today. But we did cover for about an hour in December, and I did make it public on Family Office TV, the Corporate Responsibility Act. But for those that didn't see it and may be motivated to go back and watch it, maybe the final 2 minutes before we get to some updates about you, Tom, and my close, a little bit of something to say in short order about the Corporate Responsibility Act.
Sure. So let me start by saying that although I'm a political moderate, I tend to be financially conservative, and I am not a fan of this act at all. I think this is a massive pile of paperwork that will affect 99.5% of the population with the hope that they catch 0.05 people doing bad stuff. So I'm all over getting drug dealers and criminals and terrorists. Absolutely great cause. The cost to American businesses and taxpayers as a result of this act is absolutely astronomical, and there's ongoing compliance requirements. So I am not a fan. This is just another chunk of privacy and confidentiality has been eroded, and it's gone back 25, 30 years. The Patriot Act eroded tons of things. FATCA eroded things. Know your customer. It goes on and on and on. And so there have been significant erosions in privacy and confidentiality, and as a result, families have to take great care to protect themselves. But in effect, virtually every entity, including look through to trust in many cases, you have to disclose who the owners are, who formed them, who's involved, and this paperwork is onerous, and it's virtually every entity. And if you set up new entities, they should do it immediately, get the compliance. You have an ongoing compliance obligation. For us, that's 4 to 5 pages added to shareholder agreements and operating agreements so that all the principals know exactly what their obligations are. So all of your operating agreements, shareholder agreements, partnership agreements should be updated to require compliance with this law, even though it's been challenged. I don't think it's going to be overturned, though that would make my day. And for existing businesses, you have to have it all filed and registered by the end of this year. And then you have ongoing compliance requirements. So it's a lot of paperwork. Don't ignore it. Clients say, well, that can't possibly apply to us. And I know most assuredly it does apply to you. So don't make the assumption that this is not going to impact you. You're going to have to file these things on virtually everything. You have an LLC that owns a vacation home. Guess what? You're registering. So it's a pretty significant, wildly overblown, burdensome piece of legislation. I can only hope that it somehow pays for itself in catching every single bad guy that's out there. I'm just not so sure that's going to be the result. So well intended, but this looks to me like massive government overkill. And we could have spent this money creating 3 agencies to go after terrorists. It would have been much more efficient and wouldn't affect us all or give up our privacy.
Excellent comments. I'm going to do a little bit of a brief close, and I'm actually going to give the final word because Tom does have some updates to Tom. So first of all, thank you all. It's the summer of 2024. Many of you know I'm incredibly busy. I've never been this busy. I'm really, really excited. I love to give back and do the interviews at Family Office and at Family Office TV. And I hope you find them to be deeper dive, more intellectual than often a lot of the light fare that you're getting from the so-called Family Office community. And as you know from what I did last week with McLaughlin, I do not mind debates. I actually think they're preferred and they're good, and they create opportunities to, if you're wrong, you learn, and you already know what you know. So why don't you know what you don't know and have open and honest discussions? But for those of you that want the most, that want the proprietary content that doesn't make it to the public, the opportunity to be directly connected with experts, the opportunity to meet your peers, incredible people, join go to angelorobles.com and join my private membership group. It's called SFO Continuity. We're looking for 30 founding members. We're getting closer and closer, and we have amazing, amazing families as early founding members. So the opportunity to join, and we are extremely active this summer. There is no time off, zero. It is work. There's a lot to be done. There's lots of upheaval in the community. There's lots of challenges. We're in an election year. There is a lot going on. And I guess you could say I have a lot to say, and I have a lot of incredible, incredible guests coming on. So if you found this sort of content, which is a little broader, but want something even more concise with Tom and with others and direct connections and favorable access and in-person programming, you got to go to angelorobles.com and join SFO Continuity. And that's where you're going to get, quote unquote, the most value. And you're going to be part of a very, very special private and intimate group. And make no bones about it. Again, we are extremely active, including with multiple in-person, probably 12 to 13 in-person events, intimate and very deep and impactful this summer alone, not even through the end of the year. So on that note, and you all know how to subscribe, which you should be, to my @FamilyOffice and @FamilyOffice TV. So that's 2 channels on YouTube. Follow me even more on LinkedIn, where I give away a lot of great content and resources as well. On that note, again, having known Tom for many years and his incredible insight and deep thinking, it's greatly, greatly appreciated. I would love for Tom to, one, maybe have a closing comment broadly about the subject and give my audience a little bit of an update about himself as well. Tom, I'll give it to you.
Thank you, Angelo. So first, thank you so much for having me. I appreciate the perplexing and challenging questions. I've never been bored in our conversations, and that's a good thing. And Jamie McLaughlin's a good friend. And, you know, when I find someone like Jamie that disagrees with me, he just knows that I think I'm always right and he's not. So you have to start the conversation by being really clear. When you're disagreeing with me,
like exactly,
you must be wrong. So since whoever controls the microphone wins, since he went before me, I just won, Jamie. But I think that the idea of putting in significant resources into planning is extremely cost effective. And there was a book written in 1979 when I was an accounting student, and it was an IRS district director. Everything about the IRS you wanted to know, but were afraid to ask. And in there's a full chapter on picking your tax advisor, and he ranked them from like 1 to 14. And one of the comments said, and I thought this was nonsense at the time, but he said, when you move to a new town, find the most expensive tax attorney in town and give him a blank check. Because if he's even half good, this guy will create a multiple of whatever you pay him in tax savings. And I thought that just can't make any sense. And the reality is, if you're competent, that's the case. So over an 8 to 10 year period, the more time you spend with a good tax attorney, the better off you're going to be. If I pass away tomorrow, go call somebody, because it's very cost effective. And, it's not what you make, it's what you keep. And you don't need to go near the fringe. You don't need to cross over the line, but a good advisor knows where that line is. So finally, I've been doing this for a long time. I started in public accounting and been a tax lawyer my whole life. I consider myself an advanced planner, so I do as much estate planning as I do tax planning and tying them together, which has worked well for our client base. So client base is primarily family offices, family businesses, and family foundations. That's about 85% of what we do. And the rest are wealthy individuals, celebrities, professional athletes, actors, actresses, whoever. And we just launched Handler Law. So I have some former partners returning. I have some former associates returning. I have some new partners joining me. So we're kicking things up a notch. We're not adding any new areas, but we'll pick up both Denver and Indiana offices in the process. So we're very excited and working very hard to affect that as we speak. And we haven't even announced it. That just happened.
Wow. Well, no, I'm excited you have a chance to mention that on my program. And for those, Tom, whether live or watching or listening in a recording, given that I'm assuming you may have a new email address, how can they connect and reach out to you?
Thank you. So my email address is thandler@handler.law. And the new website is handler.law as well, which just went up.
you.